Good afternoon, everyone. I hope everyone's doing fine this afternoon. Let's see, reset dates. The SAP calendar, if it's reset for the SAP calendar, it's going to be June 7th. Afternoon, how you doing today?
How you doing?
Good. All right, courtroom 2, I believe that we are ready whenever you all are.
Always, how you doing?
Afternoon.
Good. We got number 2 ready.
Okay, this is Mr. Foster. Who's representing Mr. Foster?
I am your.
Good afternoon, Ms. Giddings. Good afternoon, Mr. Foster. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
You talking to me, Mr. Foster?
I'm sorry, yes, I agree to the video.
Okay, Mr. Foster, you've been charged in case 22 CR 003256C with simple battery, family violence, and hindering a person making an emergency phone call. Afternoon, Mr. Howard. Is there a history?
Foster, second arrest. Last was 2001. Shoplifting.
Afternoon, Ms. Harmon.
Good afternoon, Your Honor. The offense date in this case is 5/23/22. The location is 11625 Windbrook Way in Johns Creek. Your Honor, the parties in this case are married. The victim in the case, who is the defendant's wife, Fallon Foster, that's Fallon, for the record, last name Foster. She indicated to officers that her husband grabbed her by the neck because she refused to give him his driver's license because he was intoxicated. She did ask the officers to come out and respond to a domestic violence call. While she was attempting to dial 911, the defendant tried to take her phone away from her. She was able to actually throw the phone on the floor and speak through the speaker to get 911 to her home. When the defendant was interviewed by officers, he admitted that he did in fact grab his wife by the neck and that he attempted to prevent her from calling the police. We were able to reach out to Ms. Foster in the case, and she indicated they are married and they live together. She doesn't fear the defendant, and she says that this is the first time it happened. She said that the defendant was drinking and that this facilitated the incident. She wants the defendant to be ordered not to drink, and she is going to be on the Zoom today. So my recommendation in this case is a $2,000 surety bond. And in spite of the fact that the victim does not fear the defendant because this contact was involving the neck, which could be, it says that he specifically didn't choke her, but it could have gotten to that point. I would recommend no further contact with the victim, stay away from the incident location, a one-day anger awareness course, no alcohol, drugs, and weapons, and per the victim request, and the state agrees, an alcohol, drug evaluation and treatment. Thank you, Judge.
All right, Ms. Giddings.
Yes, Your Honor. Can you hear me?
I can hear you, but I can't see you.
Yeah, what I did was I'm having trouble with my video. When I turn my video on, you can't hear me. It's coming
Okay.
up kind of
You're fine.
crazy, but I have my phone up. So if somebody would let me in, you'll be able to see me and hear me, and I'll just mute my, okay, somebody's letting me in now. Okay, let me turn something off. Okay, can you see me and hear me now?
Yes, we can.
Okay. I've got a couple of devices going on here. Okay. Mr. Phillips, Your Honor, has a Bachelor of Science degree in computer science from Auburn University. He is currently a computer programmer for Savas Steel Company. He has expressed to me that he is the majority financial support for the home between he and his wife. And if he is not allowed to return to work, she will not be able to maintain the home on her own. I do believe, if I heard correctly, Mr. Tucson indicated that there was a one prior shoplifting arrest. That being the case, I've spoken with Mr. Foster extensively about this case. He has no problem with random screens and no problem with not consuming any alcohol or any drugs unless they are by prescription by a licensed medical professional. He will attend 2 AA meetings a week, and we are requesting a signature bond through pretrial in the amount of $2,000 for the simple battery and $1,000 for the person hindering that of a 911 phone call, and no further violent contact. His job is still waiting for him, and they are expecting him if at all possible, to return to work tomorrow. He's very concerned about that because he does not want to lose his employment. And he understood that alcohol was a major factor in this situation and has agreed to abstain from partaking of any spirits while this case is pending.
Okay, thank you. Let's see if Mrs. Foster is on the line and would like to address the court. This is her opportunity to do so. Mrs. Foster, if you are on the line and would like to, I'll have to swear you in. Is Ms. Foster on the line? And you're not required to speak, but if you would like to speak, is this?
This is Miss Foster. Can you hear me? Because
Okay.
when I'm speaking, I cannot see anybody.
Okay, you're at the 8510 number?
Yes.
Okay, can you raise your right hand, Mrs. Foster?
Right.
Okay, your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, what would you like to tell the court?
I believe that Mr. Foster was sufficiently punished in this case. And if possible, I would definitely be appreciative for him not drinking anymore. And if possible, to not post any bail, because I don't think he is in danger of skipping the court.
Are you afraid of him?
Not at this time.
Do you want him back in the household?
Yes.
Has this ever happened before?
No.
Okay, thank you, Mrs. Foster. If nothing further, it's going to be a $2,000 SOB through pretrial for the simple battery, $1,000 SOB through pretrial for the hindering person making an emergency phone call, 1-day anger awareness. He is to have no further violent contact with Fallon Foster, random alcohol and drug screens, 2 AA meetings per week, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Foster. And you also, Mrs. Foster.
Thank you, Your Honor. I've also advised Mr. Foster that after today, he will no longer qualify for public defender services because of his income, and the appropriate referrals have been made.
Thank you.
Thank you.
Who do we have next? You're on mute. Okay.
6 and 7 is mentioned.
Let's see, who's representing Ms. Minchin this afternoon? Is she going to require a conflict attorney?
Oh, it's me, Your Honor.
Oh,
Sorry
you,
about that. I'm coming.
okay. Good afternoon, Ms. Minchin. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 003259C with obstruction of a law enforcement officer, giving false information to law enforcement, and in case 22 CR 003260C with no insurance and driving without a valid license. Is there a history, Mr. Howard?
She went to felony first appearance, so I would have to get the file from my coworker.
Okay.
Unless
Ms. Harmon, is this your case?
Yes, it is, Your Honor.
Do you have the history?
I do have some of her history noted. The first conviction was 2006, assault out of Washington State, a 2013 robbery first offender, a 2015 burglary, 2015 probation revocation, 2017 probation revocation out of Dooley County, a misdemeanor theft by taken in 2017, a 2022 ag assault reduced to disorderly conduct. And the conviction tape was 4/4/2022 in Fulton. She's currently on probation for 12 months. Your Honor, in the first case, the 2/16/20 date that occurred at 1560 Holcomb Ferry Road in Roswell. Defendant actually reported her car stolen to officers. The officers went to the incident location. She gave the officers the name of Cassidy Brown. Officers checked that name in GCIC and NCIC and found a warrant for a probation violation in her actual name. She was advised of the warrant. She went inside to leave her daughter in the care of her son. And as she was walking back up the stairs to go back outside with the officer, she fled out of the door and took off running. In the second incident on 5/23/22, that's 1100 Holcomb Ferry Road, Roswell. Officers were in patrol in the area. They ran the defendant's tag. The tag check indicated that there was no insurance. So the defendant was pulled over. The driver, who was the defendant, indicated that she was driving her father's car and she didn't know it was not insured. She was unable to produce a license for the officer. She stated that her name again was Cassidy Brown. And the officer did a check of the system and found that there was no license issued. He also located outstanding warrants in her actual name. And then she admitted that she actually did give the officer a false name. Your Honor, I believe that she does have a flight risk. She has a 2016 FTA on her driver's record. Her actions in both of these, in the first case, when she took off running, indicates that she is a flight risk. I already gave you her criminal history. And I do think it's important to point out in the second offense or the subsequent offense in 2022, she gave a false name again, showing that she has a propensity to reoffend. And the fact that she is actively on probation as of 4/4/22 and crimes are still being committed. In the first position 6, we would recommend a $1,000 surety bond for the obstruction of law enforcement officer, a $1,000 surety bond for false name. In the second offense, we would recommend a $500 surety bond for no insurance, and a $500 surety bond for driving without a valid license. Nothing further, Judge.
Okay. Ms. Kim, she's going to get a signature bond, $1,000 signature on the first case, obstruction, 1,000 signature through the jail. The second, giving false name, 1,000 signature through the jail, making it a total of a $2,000 signature bond through the jail. No drugs, alcohol, or weapons. On the second case, no insurance, $500 signature bond through the jail, and for the no license, $500 signature bond through the jail, making it a $1,000 signature bond through the jail. No drugs, alcohol, or weapons on that case also. Is that fine with you, Ms. Kim?
Yes, Your Honor.
Your Honor, can I add one more condition to the second offense? No driving without a valid license.
Well, nobody should be driving without a valid license, so I'm happy to put that down, Ms. Harmon. Okay. All right. Good luck to you, Ms. Meacham.
Thank you.
Next, we have number 12, Ms. Washington.
Who's representing Ms. Washington? Is Ms. Washington in need of a conflict attorney?
No, it's me, Your Honor. Conflict attorney is for 9 and
Oh,
10.
okay.
Yes, sir.
Okay, thank you. Good afternoon, Ms. Washington. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Hey, Ms. Washington, can you hear me?
Yes.
Okay, thank you. You've been charged in case 22 CR 0032638A with fare evasion. Good afternoon, Ms. Webb.
Good afternoon, Your Honor.
Are you all going to seek a surety bond on this case?
Your Honor, the state is actually going to do a $2,500 signature bond because I believe she has felony holds for a FTA on the 2018 arson charge. And just to give a brief overview of the facts, yesterday, Ms. Washington was accused of skipping fare at the Garnett station located at 225 Peachtree Street. Your Honor, I did have a chance to look at her history. She does have 12 cycles, including 2 open cases, one for aggravated assault in 2019 in Fulton and arson in first degree, which she's on probation for. And she failed to appear to the Atlanta DCS office within 24 hours and never completed an outstanding MHC order. So for those reasons, it looks like she does have some felony holds. So we're requesting a $2,500 signature bond with a stay away from MARTA and no alcohol, drugs, or weapons.
You have an objection to that, Ms. Kim?
No.
No? All right, so $2,500 signature bond through the jail, stay away from MARTA. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Washington.
Thank you.
Next we have number 10, Mr. Ringer.
Good afternoon, Mr. Ringer. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Good afternoon, Your Honor. This is Gloria Hawkins Wayne. I wanted to apprise you of the fact that I have been retained as counsel and had not had an earlier moment to make that announcement. It pleases
Okay.
me.
Very
Thank you.
good. Thank you, Ms. Hawkins Wynn. Let's see, Mr. Ringer, you've been charged in case 22 CR 003265F with criminal trespass, family violence, and simple battery family violence. Is there a history, Mr. Howard?
This 5th arrest, 2018 possession of cocaine, 2011 trespass, no law, and a marijuana arrest from 2011, misdemeanor. He had 2 of those from 2011. That's it.
All right. Ms. Webb?
Under this incident occurred on May the 5th at 8167 Colquitt Road, Unit A, Sandy Springs, Georgia. Around 2:00 p.m. that afternoon, Sandy Springs Police Department responded to a domestic dispute call and were met with the victim, Miss Angel Parker. That's Angel common spelling, Parker common spelling. And she advised that the defendant was the father of her children. They had a verbal dispute that quickly turned physical. She alleged she thought that the defendant pushed their daughter, who was standing in the doorway at the time. Even though she didn't see it, she thought she heard that he pushed her. So she ran up to him and pushed him, and he pushed her back and then began striking her in the face, on the forehead area, and then threw her cell phone, and shattered it. She did not have any visible injuries. The parties do reside at the incident location together and do share 2 minor children. Your Honor, the state is making a recommendation for a $1,500 surety for the trespass offense, $2,500 surety for the simple battery, totaling $4,000 surety with a stay away, no further contact, and no alcohol, drugs, or weapons. Our office did attempt to make contact with Ms. Joyner. I do believe she's on the call, but we were not able to make contact with her, but we are concerned with the risk of reoffense, Your Honor.
Okay. Ms. Hawkins Wynn?
I misunderstood the state. Ms. Joyner, I believe her name is Ms. Parker, who's the
yeah, I'm right here.
Yeah.
Can you hear me?
Excuse me. I meant Ms. Parker. I'm sorry.
Parker. Absolutely. Your Honor, the defendant is requesting a surety bond. As you just heard, that there's no prior evidence of any physical contact between the parties, that Ms. Parker mistakenly believed According to the defendant, he was closing the door, but she mistakenly believed that he had pushed the child. And that's when she pushed him back and kind of started this tit for tat. But again, it was based on a mistaken belief that as he was trying to close the door to keep the 2-year-old from exiting, that she believed that something else was going on and pushed. And that's how this started. There is no prior history of physical contact. They've been together for 5 years. They have 2 children. They're very much so supported by the families, absolutely the family of Mr. Ringer. I believe they share an apartment that is in part supported, if not by signature, through the parents. I believe, again, that there's no other evidence that Mr. Ringer's ever failed to appear in court, and that we would ask the court to grant a surety bond while the case is pending. Give me a surety bond, forgive me, Your Honor, or bond on these charges. On this charge, it's one simple charge, I believe, of criminal trespass to property.
Okay, so I have a charge of criminal trespass and simple battery, correct?
That is correct, Your Honor.
Well, yeah, and I believe the simple battery is negated by the evidence that the victim herself has said that she mistakenly believed that he pushed the child when pushing the door, and that she began the shove.
And I'm here. Can you hear me?
Ms. Parker, yes, I can hear you. I will get to you in turn, and I will give you the opportunity to speak to the court if you would like, and just give the court a moment, okay?
Okay, I was just making sure you can hear me. I'm sorry. Thank you.
Yeah, that's fine, Ms. Parker. You're fine. Yes, Ms. Hawkins-Wynn, the state has accused Mr. Ringer of criminal trespass and simple battery. I believe those accusations have been drawn up. Is that not correct, Ms. Webb?
That is correct, Your Honor. And the state made those accusations based on what was provided in the warrant and police report, where the responding officer advised that Ms. Parker told him that when he pushed her back, he began striking her multiple times in the head. No visible injuries, so that was sufficient evidence for the simple battery accusation, Your Honor.
Ms. Hawkins-Wynn?
Yes, Your Honor, but I think, again, who knows exactly what was going on at the scene, but what Ms. Parker is saying, that she mistakenly believed something happened and she began to push him. And that's why and I think it durated only a moment before he decided to leave, before it escalated. That is
okay.
What I think the evidence would show.
Okay. I will have to grant a bond on each of the charges, though. So the rest of the argument will be left for a later time. Ms. Parker, if you would like to speak, I will need for you to raise your right hand and I'll need to swear you in. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
What would you like to tell the court?
I just want to tell y'all that he's a great father, and we've been working together. We've been civil. Yeah, and then as Miss Gloria said, I initially thought that he might have pushed her, but I couldn't see, and I later confirmed that that wasn't true. So yeah, and then also Mr. Ringer, he works at Cheesecake Factory, and he's in jeopardy of losing his job. They want him back there tomorrow or as soon as possible.
Does he live with the Colquitt Road address, ma'am?
8167.
Yes. Do you both live at that address together?
Yes.
Okay. And you're not afraid of him?
No, I'm not afraid of him.
And this has not happened before?
No, this is the first time.
Okay. Thank you, ma'am. I am going to grant him a signature bond. Okay, so it's going to be $1,000 signature bond on each charge, which makes for a $2,000 signature bond. That's going to go through pretrial, 1-day anger awareness, no further violent contact with Ms. Parker, and no drugs, alcohol, or weapons while out on bond. So he'll be able to get out and go back to his job. Okay.
Thank you, Your Honor. 7-year.
Thank you so much.
Thank you, Your Honor. He's a 7-year employee at Cheesecake. Thank you very much.
Yeah, he's great. He's the backbone of the. He's the backbone.
Nothing further, Your Honor. May I be excused? Nothing
yes,
further,
you all have a good day. You also.
Thank you so much.
Thank you, sir.
Who do we have next?
Number 13, Mr. Wise.
Good afternoon, Mr. Wise. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, and good afternoon, Your Honor.
Thank you. Mr. Wise, you've been charged in case 22 CR 003268G with battery, family violence, and criminal trespass. Is there a history, Mr. Howard?
Mr. Wise,
6 total. Last arrest, 2012 out of Texas. Public intoxication. Yeah, the 2012 arrest in Georgia. Carrying concealed weapon. Before that was a 02 DUI. And he had history out of Virginia. But that goes back to the 90s. That's it.
Okay. Ms. Webb?
Yes, Your Honor. This incident, well, there's actually 2 incidents involving the same victim at the same address, Your Honor, which is 4036 Braxton Place, Southwest Atlanta, Georgia, 30331. The first incident occurred on April 6, 2021, where Atlanta Police Department responded and they were met with Miss Ashley Head. That's Ashley, ASHLEIGH, Head, common spelling, who explained that the defendant was her ex-boyfriend at the time and had come to her residence approximately 2:30 in the morning because he accused her of having an affair, and he busted her windshield of her white 2007 Mercedes-Benz CLK 350. V number is W as in woman, D as in dog, B as in boy, T as in toy, J as in joy, 5, 6, H as in house, 8, 7, F as in floor, 222117. Your Honor, on the October 31st event, the defendant allegedly entered into that same residence while Ms. Head was sleeping in the bedroom and woke her up and told him that he wanted out of the relationship. She told him to leave, and the two began to argue and became physical with each other. And he pushed her into the bedroom closet and began punching her in her head and face area several times with a closed fist. The officer did note that she did have a bruise on her elbow and a mark on the left side of her face, but she bruising on the left side of her face, but she refused a medical attention. Your Honor, in this particular case, the state is recommending for each charge a $2,500 surety bond, totaling $5,000 surety, a stay away from the incident location, no alcohol, drugs, or weapons, 1-day anger awareness, and no further contact with Ms. Head. Your Honor, these 2 incidents, of course, occurred 6 months apart from each other. However, again, they do involve the same victim and the same address, Your Honor. On top of that, we did make a contact with Ms. Head, and she has told us profusely that she does not want to participate in the prosecution process, and she intends to do just that, Your Honor. We are extremely concerned with the risk of reoffense and witness intimidation in this case, Your Honor, considering the violent cycles that appear to be happening, and based on the conversation that we had with Ms. Head today.
Okay, thank you. Ms. Kim?
Yes, Your Honor. Mr. Wise is 37 years old. And Your Honor, this happened April 2021 and October 31st, long time ago. Indeed, they didn't even know that there was warrant out here. So Mr. Wise turned himself in yesterday, voluntarily. Indeed, Miss Ashley Head was the very one who drove him to the jail to be turned in, and they are still in the relationship. They don't live together. There's no other incidents, and they have a good relationship right now. These are all remote, and it's done deal. It is in the past. Mr. Wise has been here in Georgia for more than 20 years, and they don't have children together. He's been working as a radio engineer at the studio, his own studio, for more than 10 years. He has graduated from high school. He has a certification from electrician, and he does not have any other significant incident other than this. We would like to request for signature bond so he can go home and move forward. Thank you.
Okay, it's gonna be a $2,000 signature bond through pretrial on each count, making it for a total of a $4,000 signature bond through pretrial, 1-day anger awareness. No further violent contact with Ms. Head, and no drugs, alcohol, or weapons while out on bond.
Thank you.
Good luck to you, Mr. Wise.
Next, we got number 9, Mr. Nesbitt.
Good afternoon, Mr. Nesbitt. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Nesbitt, you've been charged in case 22 CR 003262H with reckless conduct. Is there a history, Mr. Howard?
His 4th arrest. Last arrest was 2004 for battery. It was dismissed.
I'm sorry, go ahead.
I said the last arrest was 04 for battery. It was dismissed. That's pretty much it.
Okay. Is Mr. Nesbitt in need of a conflict attorney?
Your Honor, Owen Lynch, and I believe I've been appointed as that conflict attorney.
Oh, okay, good. Good afternoon, Mr. Lynch.
Good afternoon, Judge.
Let's see, Ms. Webb?
Yes, Your Honor, this incident occurred on May the 20th when the defendant is actually a MARTA bus operator, a passenger, Mr. Kerwin Kirkland, that's Kerwin, Kerwin, Kirkland, Kirkland, reported to the MARTA police at the North Avenue station that the defendant pulled a gun on him while they were arguing on bus 8006. Allegedly, and according to Officer Garman with MARTA PD, he reviewed the surveillance footage and saw the victim bypass a patron who was sitting in a wheelchair. The two began arguing over the victim stepping in front of that disabled patron, and they began cursing each other out. While the defendant was driving, he reached between his legs into a gray bag and pulled out a black pistol, racked the side and placed it on his lap and stated, "Now what you talking, huh?" The bus was full of MARTA patrons, of course, Your Honor, and he continued to drive until they reached that North Ave station at the Hunt Street intersection, and the victim was able to make contact and file a report with MARTA PD. The state is recommending a $3,000 surety bond, a stay away from MARTA unless otherwise permitted by his employer, no further contact with Mr. Kirkland, no alcohol, drugs, or weapons, and 1-day anger awareness. Your Honor, we are concerned that the defendant is a possible threat to the community as their bus was full of passengers at that time, Your Honor, and he had a firearm. There's a reason why the Georgia legislator has legislated not to have firearms in public places, particularly places of transportation, Your Honor, for these particular reasons. We are, of course, applaud him for taking up for that disabled patron, but there are several other avenues that could have been exercised, and certainly resorting to possible gun violence would not have been one of those. That gun could have fell off his lap and discharged and hit himself or someone else who was on that bus that day, Your Honor. Nothing further.
Mr. Lynch?
Your Honor, my client's 54 years old. My understanding is he has a very limited criminal history, if any, to speak of. He has worked at MARTA since 2019. He's a resident of Powder Springs in Cobb County. Before working at MARTA, he did work at the airport for an extended period of time. My understanding is that my client is going to contest these charges and the allegations. Understand this is not the time to do that, but I would request that Your Honor set a signature bond in this case, just based on his lack of a criminal history. I don't think he should have no issue with staying away from the alleged victim in this case. And that's what we would request, Your Honor. Certainly the allegation would be out of character for my client, and his criminal history would reflect that.
Okay, it's going to be a $10,000 signature bond through pretrial. Stay away from Kirkland. Abide by any MARTA restrictions, and no drugs, alcohol, weapons while out on bond. All right, good luck to you, Mr. Nesbitt.
Thank you. All right, let's got number 4, Mr. Hockenberry.
Your Honor, that concludes my business with the court today. May I be excused?
Yes, have a good day, Mr. Lynch.
Thank you, sir.
Good afternoon, Mr. Hockenberry. I am Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
You have been charged in case 22 CR 003258A with theft of service. Their history, Mr. Howard?
No.
Ms. Harmon?
Yes, Your Honor. In this case, the state is recommending a $2,000 signature bond and to stay away from the incident location of 180 Walkerway Southwest. That is the location of No Mas Cantina. Yes.
I take it you don't have any objection to a signature bond, Ms. Giddings?
No, Your Honor, I do not have an objection to a signature bond.
Okay.
I do need to ask, though, even with the stay of order, if Mr. Hockenberry wishes to reconcile the $69.93 food tab, will he be allowed to mail a money order to the restaurant?
Your Honor, I feel like that would probably be acceptable to mail it over there, or if he wanted to make that kind of arrangement, we could ask you to order a one-time law enforcement escort so he could pay that bill.
I don't think the police will escort him to do that. Which is why I asked.
I have no objection to him mailing the money in,
Okay.
Unless the state has an objection.
I just didn't want him on the premises, period, even with the police escort. But normally the police will only escort in DV cases to get property. They won't be involved in like a restitution type issue, is my understanding, which is the request for mail.
Understood. Let me defer to ASC.
There's no
Walker.
objection. And obviously, I'm not making any promises as far as him making the payment, but there's no objection to him placing payment via mail.
Thank you, Mr.
Okay, so it's gonna be a $2,000 signature bond through the jail, stay away from Novas. And he will mail the $69.93 to Novas. All right, good luck to you, Mr. Hockenberry.
Thank you.
Number 3, Mr. Green.
Good afternoon, Mr. Green. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Green, you've been charged in case 22 CR 003257D with loitering and prowling and criminal trespass. Is there a history, Mr. Howard?
6 total. Last arrest was 2020 trespass, violation of family violence order out of DeKalb. 2019 misdemeanor possession of marijuana, violation of family violence order. 2019 simple battery family violence. And a 2016 out of DeKalb battery DB. You got first offender for that. And the disorder comes up.
Ms. Harmon?
Okay, thank you, Your Honor. The offense date is 5/23/22 and the location is 2620 Santa Barbara Drive, Northwest in Atlanta. And this occurred in the area of 3 o'clock in the morning. The defendant and his girlfriend were at the victim's home drinking beer at 2 a.m. And the victim, for the record, is a woman named Alfonza Simmons. Her first name is ALFONZA, last name Simmons, common spelling. So they were drinking beer at her house. The defendant and his girlfriend got into like a verbal altercation and left the premises. The defendant, however, returned to the incident location and began pulling on the doorway and banging on the door as if he was trying to get in. And this was at 3 o'clock in the morning. She left the home. She heard a window break, the victim, I'm sorry. She heard the window break and then she went outside to kind of check it out. And she saw the defendant in his vehicle right in front of the home. She called the police out of safety concerns and he was still on the premises when the police arrived and he was arrested. I think he presents a danger to the victim based on the incident details. I'm also concerned that there are 2 violations of family violence order orders in 2019 and 2020 that does show he does have some propensity not to follow the court order. Our recommendation in this case, Your Honor, he was actually given a $5,000 surety bond for the loiter prowl. And we're recommending a $1,000 surety bond for the criminal trespass, damage to property, no further contact with the victim, stay away from the incident location, a one-day anger awareness, and no alcohol, drugs, or weapons. Thank you, Judge.
Ms. Giddings?
Yes, Your Honor, I need to ask first because the information that I received, I do not see a warrant for the criminal trespass charge, and it is not on his booking sheet. Is that something the state added on its own?
Yes.
Okay. Well, Your Honor, first of all, with there being no warrant for the criminal trespass charge, we would ask for a signature bond through the jail for that. Unless Your Honor is inclined to do a signature bond for the entire case. If not, a split bond of $1,000 signature bond through the jail for the criminal trespass charge and a $1,000 signature bond if Your Honor so inclined. If not, a $1,000 surety bond for the loitering and prowling. Mr. Green is a mobile mechanic. He has a contract with an independent shop owner. He has a BS degree in motorsports from North Carolina A&T. He has one daughter who is about to turn, 2 years of age, and he currently lives with his grandmother and helps to take care of her and support her. He would like to proffer to the court that the allegations are not as they have been reported by the officer. In fact, he indicates that he was sitting in his vehicle outside the home and did not leave because he didn't even know the police had been called. He had no reason to flee. He says that he was knocking on the door waiting for his significant other to come out of the house, and it was taking her so long to get out. And he was like, "What's going on?" They were actually in the process of leaving, and Miss Alfonso Simmons was actually asleep. He said he was not around the back of the house. He had no need to be around the back of the house, so he doesn't know anything about a broken window or how that happened. He was knocking on the front door saying, "You need to hurry up. It's 3 o'clock in the morning. We need to go. We got to get home." And the next thing he knows, he's sitting in his car waiting for her to come out, and the police roll up. He has no idea what's going on. Under the statute, if you do a strict reading and construct of the elements of loitering and prowling, I would suggest to Your Honor, the state's going to have an issue if this goes to trial because it does not meet the elements of loitering and prowling as set out and the intent of the state legislature for actually putting that offense together. And so that is what we would ask for instead of the $5,000 surety bond that was listed as a scheduled bond by the jail.
And Your Honor, there is some factual disputes between the state and the defense rendering of events. My understanding and my reading of the information is that the defendant's girlfriend had already left the home. They left the home together. They got in his car together. They drove off, and the girlfriend got out of the car and walked the rest of the way to wherever she was going. My understanding is that the defendant returned to the home alone. So there is some factual dispute in this case. Furthermore, Your Honor, this case has been accused. I don't know what a warrant would have to do with a signature bond or a surety bond, but the case is accused, and an accusation cures any problems with any not having a warrant. So Your Honor is free to issue a surety bond in this case if he so wishes. And so our recommendation would stay the same in light of the fact that factually, the information I have says that he was not knocking on the door, he was banging on the door, and it was 3 o'clock in the morning. And furthermore, Your Honor, if this was not a concern for the victim, I don't think she would have called the police. They were just drinking beer together an hour before. So obviously something raised her feathers and she felt like she needed to get assistance from officers. So that's my response to the defense argument, Your Honor. Thank you.
Which is why it's called an allegation, Your Honor, and there was no warrant issued, notwithstanding an accusation. The state can charge whatever they want to charge, whenever they want to charge it, but there is no warrant that would hold him in custody because the officer did not get one, and he could have if he felt that criminal trespass damage to property was an issue, and he did not.
All right, so for the loitering and prowling, It's gonna be $1,000 good bond for the criminal trespass. It's gonna be $1,000 signature bond through the jail, making it for a total of a $2,000 split bond. Stay away from this. No further contact with Ms. Simmons. Stay away from the Santa Barbara address. No drugs, alcohol, or weapons while out on bond. Good luck, Mr. Green.
Thank you.
Thank you, Your Honor.
Who do we have next?
Number 5, Mr. Jordan.
Good afternoon, Mr. Jordan. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jordan, you've been charged in case 22 CR 003261A with battery family violence and 2 counts of cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
24 total. Last arrest was last month. Terrorist threats and obstruction. That's 22 CP 208639. That's an open case in state court for simple assault family violence, simple battery family violence, trespass family violence. 22 CR 000684A as an apple. Let me go to the Florida history real quick. 2016 probation violation, 2020 grand theft auto, leaving the scene of an accident, 2016 ag assault with deadly weapon conviction, 2015 battery second and subsequent offense conviction, 2012 battery second and subsequent conviction. 2009, that was the original battery conviction. Got a fade to appear from 08 out of Florida. That's it.
Ms. Webb?
Yes, Your Honor. This event occurred on yesterday around 7:30 in the morning at 1457 Raintree Drive, Unit B in Roswell. The Roswell Police Department responded to a domestic dispute call at that location, and the victim is Shekinah Graham. That's Shekinah, SHEKINAH, Graham, GRAHAM, advised that she and the defendant began to argue after she returned home in the early hours of that morning. The argument turned physical when the defendant backed her into a wall with his hands around her throat. The victim advised to the officers that he began to strangle her and pushed her against that wall outside of the residence. While he was choking her with his hands, she slid down to the wall to escape his grip, and he kicked her in the face with his knee. She attempted to leave the home and had 2 minor children in the car, and a neighbor came over to assist with her leaving. Once outside the home, the defendant kept getting into her personal space, and the neighbor testified to the officer that she did slap him, but according to the neighbor, it was in self-defense and to get him away from her. The parties then proceeded to again continue to quarrel outside that home with the children in the car, and the defendant allegedly pushed her over a couple of bags of trash bags outside and against a brick wall, causing her to injure her elbow. The defendant then entered his car and increased his rate of speed, according to that neighbor, and attempted to prevent her from leaving. And subsequently, he was struck by her car because he was blocking her from leaving out. Your Honor, the state is making a recommendation for a total $7,000 cash bond, $5,000 for the battery, and $1,000 each count for the cruelty to children. Stay away from the incident location. No further contact with Ms. Graham. No alcohol, drugs, or weapons. Third-party transfer of the children, and 1-day anger awareness. Your Honor, as you've heard from pretrial, there is an open pending case in state court. Case number 22 CR 00684A, where Judge Mincy ordered the defendant to stay away from that incident location and to have no further contact with that same victim, Your Honor. We did make contact with Ms. Graham. She did advise that she was aware of that case, but it was her understanding that the case was closed. And our victim advocate advised her, told her, no, indeed, that case is still pending and open. Your Honor, as you've also heard from pretrial, the defendant has just been released on a felony terroristic threats on April 30th. And not even a month later, Your Honor, we're here again on another act of violence. So the state is concerned with the risk of reoffense, and we are seeking that cash bond today.
Kim?
Yes, Your Honor. Mr. Jordan is 39 years old, and they do not have a relationship anymore. It seems like they broke up. He has been here in Georgia for about 8 months, and he works at the gas station, and he has been working there for about 1.5 months. He graduated from high school. He even has associate degree for business management. And we would like to request for, considering all these histories, we would like to request for $1,000 surety bond instead of cash bond, Your Honor. Thank you.
Okay, so for the battery, family violence, we have $5,000 good bond. For each of the cruelty charges, $1,000 good bond, which makes it for a total of a $7,000 good bond. No further contact with Ms. Graham. Stay away from the Raintree Drive address. Third-party transfer for visitation of the children. No drugs, alcohol, or weapons while out on bond.
Did we have one-time escorted law enforcement
And
officer?
if he has any belongings at the Raintree Drive address, he can go there on one occasion with law enforcement to retrieve any belongings that he might have there.
Thank you.
Okay, good luck to you, Mr. Jordan. Who do we have next?
Number 8, Mr. Metz. Mr. Metz.
Good afternoon, Mr. Metz. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Metz, you've been charged in case 22 CR 003267E with reckless conduct, discharge of a firearm on property of another, and criminal trespass and damage to property. Is there a history, Mr. Howard?
6 total. Last arrest was October 2020 for DUI. Before that was 2017, sale of marijuana. Possession of drug-related objects, it was dismissed. 2013, shoplifting. 2011, disorderly conduct. And 2011, a Ferry trespass that was dismissed. That's it.
Okay, Ms. Webb.
Your Honor, this incident occurred yesterday at 3793 Hempstead, that's HEMPSTEAD Way, Atlanta, Georgia, where Atlanta Police Department responded to shots fired call. Officers were able to locate once arriving to the scene where the shots were coming from and found the defendant standing on the victim, Ms. Shantae Meadows. That's Shantae CHANTAI Meadows MEADOWS driveway, Your Honor. Officers commanded for him to put his hands up, and he started walking towards a porch where he placed the firearm behind the wall. He was detained and placed under arrest. When officers actually made contact with Ms. Meadows, she advised that the defendant was attempting to get into her home, and she heard somebody at her door, and she told him to go away, and she was going to call the police. The defendant then allegedly ripped out her Ring doorbell, Your Honor, and began knocking things over at her porch. And he appeared to, and according to the responding officers, he did appear to be under the influence of some type of drugs or alcohol. The state is making a recommendation for a $3,500 surety for the reckless conduct, $1,500 surety for the criminal trespass, $2,500 surety for the firearm, totaling $7,500 surety, a stay away from that incident location, no alcohol, drugs, or weapons, 1-day anger awareness, and no further contact with Ms. Meadows. Your Honor, we are concerned that the defendant is a possible threat to the community. We did try to make contact with Ms. Meadows to see if she has any relationship to the defendant, but based on the officer and the warrant, it does not appear to be that case. And we are concerned that he was just standing in her driveway firing off a gun, Your Honor, and attempting to get into her house.
Ms. Kim?
Yes, Your Honor. Mr. Metz is 31 years old. He has a master's degree in business administration, and he has been working. He's gainfully employed as a supervisor at warehouse. He's been working there for about a long time anyway. He has a stable job. He has been here in Georgia for more than 30 years. What happened was, because of DUI in 2020, he did not want to drive under the influence of drinking. So he drank with his friends, and then his friend dropped him off at 3777 Hampstead instead of his place is 3783. So he was dropped off at his neighbor's place. However, he didn't know that it was his neighbor's place. He thought it was his house. And he does not remember any of these incidents at all, those details. He has no clue what happened. He was blacked out. And there was no intent in terms of having all these incidents, and we would like to request for signature on bond. And yet, if your honor is not inclined to give him a signature on bond, we would like to request for $1,000 a surety bond for each charge. Thank you, your honor.
All right, so it's going to be $1,000 good bond on each charge, making for a total of a $3,000 good bond. Stay away from the Hempstead Way address. No further contact with Ms. Meadows, and no drugs, alcohol, or weapons while out on bond. Good luck.
Your honor, the proximity between his house and his neighbor's house is very short. So stay away. Can we have a clear exception that he can go to his house?
Of course, he needs to stay away. What's the address of the alleged victim, Ms. Webb?
Yes, 3777.
3793 Hempstead Way.
3793. Okay, stay away from 3793 Hempstead.
No problem.
All right, good luck, Mr. Metz.
All right, we got Mr. Walker, number 11.
Okay. Good afternoon, Mr. Walker. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Walker, you've been charged in case 22 CR 003266B with battery family violence. Is there a history, Mr. Howard?
This fifth arrest. Last was 2015, a free. Disorderly conduct, simple assault, family violence. They were dismissed. Before that was 06 DUI. And then 1994 ag assault first. That's it.
Okay, Ms. Webb?
Yes, Your Honor. This event occurred on May the 22nd at 1685 Virginia Avenue, Unit 4, College Park, Georgia, 30337. The Atlanta Police Department responded to a domestic dispute call and were advised by the victim, Ms. Kelly Joyner, who I believe is on the call, Your Honor. That's Kelly, Kelly Joyner, that the defendant is the father of one of her adult children. She was preparing dinner in the kitchen and the defendant came in accusing her of having an affair with a former love interest. She advised that she didn't want to argue with him and she simply ignored him. Then he began to curse at her and throwing grapes at her, and then walked up to her and struck her in the face with an open hand, and then began striking her in the face with a closed fist. The officers did notate and take pictures of her injuries, which included a swollen right arm and right cheekbone, and she was treated by EMS on the scene. The parties grandchildren were present at the scene and confirmed that the defendant did strike their grandmother several times in the face, Your Honor. The state is making a recommendation for a $3,000 surety, a stay away from the incident location, no alcohol, drugs, or weapons, 1-day anger awareness, and no further contact with the victim, Your Honor. We are concerned with the risk of reoffense. Our office did attempt to make contact with Ms. Joyner earlier, but we weren't able to, but it does appear that she was able to be here. But considering the underlying facts of this case, Your Honor, and a possible ongoing dispute, we are concerned with a risk of reoffense. Nothing further.
Thank you. Mr. Kim?
Yes, Your Honor. Mr. Walker is actually 54 years old, and he has been here in Georgia for the last 54 years. This one is recommended by pretrial services to release him without unsecured judicial relief is recommended, and we would like to request for signature on bond. He's willing to stay away from that location because he has a friend's place that he can go to. He has a family here in Georgia. It's not a flight risk. He has a solid job. He works at a warehouse for last 8 years, same clinic. And his education level is 11th grade. from high school. And I think he is qualified for signature on bond. Thank you.
Okay, let's see. Ms. Jordan, if you are on the line and wish to address the court, now is your opportunity. You do not have to address the court, but if you would like to, this is your opportunity. I don't think I see her there anymore. Okay, as such, it's going to be a $3,000 signature bond through pretrial, 1-day anger awareness. No further contact with Ms. Jordan. Stay away from the 1685 Virginia Avenue address. No drugs, alcohol, or weapons while out on bond.
May we please have a one-time law enforcement officer visit?
Yes, and a one-time escort to retrieve any belongings that might be at the Virginia Avenue address.
Thank
Your
you.
Honor, what was that bond amount again? I'm sorry. My computer-
$3,000 signature bond through pretrial.
Thank you.
It appears that Miss Jordan is back, Your Honor.
Okay. Ms. Joyner, I did not know if you wish to address the court. If you do wish to address the court, I'm happy to hear what you have to say. If you do want to address the court, you'll have to unmute yourself and I'll have to swear you in, but you are not required to. Okay, I see you talking, but you're on mute.
Okay, can you hear me now?
Yes, ma'am. Raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
I would like to say that I want to give him like 3 weeks to get his stuff, do what he needs to do, and just leave.
Okay, well, Ms. Jordan, I've already ordered that that he cannot have any further contact with you and that he cannot, that he can only go back to the Virginia Avenue address on one occasion with law enforcement to retrieve any of his belongings, okay? Counsel has told me that he has someplace else that he can stay in the meantime.
Okay.
All right?
Okay.
Okay.
Does he get a signature bond?
Yes, ma'am, he does.
Okay. Thank you.
You're welcome. Any other questions for me?
No.
All right. You have a good afternoon, ma'am.
You do the same. Thank you. Bye-bye.
Bye-bye. Who do we have next?
Should do it.
Reverend Clark.
A question, position 1, Lawrence Clark. I interviewed him, Your Honor.
Courtroom 2.
Yeah. If we told that he waived his appearance.
Ms. Giddings,
He didn't tell me he was waiving his appearance, but I will defer to Your Honor. I did speak with him and he knew that I would be addressing his issues today in court.
well, I take it that you did not follow a written waiver of appearance.
No, no.
Okay. Is there any way that we can get Mr. Clark?
Your Honor, he's very combative. Ms. Giddings seen that when he was talking to her on the phone. He did tell me that he waived his appearance with her. I wasn't standing next to him when he asked, if he did ask, but he's extremely combative.
Okay, so Ms. Giddings, could we reset him for tomorrow?
We could, Your Honor. As just that he didn't say that to me, and so I'm hesitant to do so. The only difference is he does not even have any bonds set, and normally these type of charges would have even scheduled bonds through the jail. So I'm not sure why there aren't any whatsoever. And this is a warrant out of magistrate court for Fulton County. So I'm not sure what's going on there. But he was a little bit until he realized he was actually speaking with me specifically, because I'm very familiar with Mr. Clark. He was a bit high strung today. I will defer to Your Honor. I don't not take the corrections officer's word that if he told him he was waiving his appearance and he didn't want to be present, I can't take him at his word for that. But again, I'll defer to your honor.
Well, I'm happy to proceed if you want to waive his appearance. If he's combative and is making it difficult for the jail, I would think that would be a medical reset given his attitude, and we can reset him for tomorrow. And you can file a written waiver of appearance if you need to, or he can be present in person.
Yes, and Your Honor, that would be the state's position. I believe we had something like this in another bond hearing, and I think PD Kim was able to speak to what the public defender's procedure would be in an instance like this. But at the conclusion of that other matter, we were more comfortable with the defense counsel actually speaking to the defendant and getting the waiver of appearance directly from the defendant. So we would ask for a reset, Your Honor.
Any objection to that, Ms. Giddings?
No, Your Honor, we're probably going to end up back here tomorrow. It's just that I would ask that they make it very clear that he must tell counsel, because it won't be me, that he must tell counsel he's waiving his appearance. But I can give this, in case he causes an issue tomorrow, I can give some basic information about him to know exactly what his status is regarding.
Your Honor, me and a couple other officers, we're gonna go upstairs and go get him right now. We're just gonna go get him right now. Give us a few minutes.
Okay.
Okay.
All right, thank you. We appreciate it. Let's see, why don't we go over the calendar? Because Mr. Clark is the last defendant today. I have Ms. Bridgewater in court with me, so when she is ready, we can go over the calendar, and then we'll be in recess until Mr. Clark comes.
Okay.
Harmon, Michael.
Again, the reset date for the SAP calendar is going to be June the 7th. We're waiting on Mr. Clark to come down, and he is position number 1. Position number 2 is reset further notice with a $3,000 total SOB through pretrial. Position 3 is reset to the SAP calendar with a total $2,000 split bond. Position 4 reset further notice with a $2,000 SOB through the jail. Position 5 is reset to the SAP calendar with a $7,000 total split bond. Position 6 reset further notice with a $2,000 total SOB through the jail. Position 7 reset further notice with a $1,000 total SOB through the jail. Position 8 reset to the SAP calendar with a $3,000 total good bond. Position 9 reset further notice with a $10,000 SOB through pretrial. Position 10 reset further notice with a $2,000 total SOB through pretrial. Position 11 reset further notice with a $3,000 SOB through pretrial. Position 12 reset further notice with a $2,500 SOB through the jail. And position 13 reset further notice with a $4,000 total SOB through pretrial. Any questions, comments, or otherwise? Okay.
All right, so we will be in recess until courtroom 2 rejoins us.
Don't worry about it. Your Honor, we here. Yeah, sit down.
No, sit here. Yeah, sit here against the one.
Yeah, that is. I thought that was her. That's the wrong name. Yeah, that's Ms. Giddings.
Okay, good afternoon, Mr. Clark.
Judge Morrow, how you doing?
I'm doing well, sir.
I'm in a lot of pain, sir. I have a neck injury. I have a fractured skull. I'm in a lot of pain, sir. I tried to wave, like have my wife's wave this morning.
All right.
I talked with Ms. Giddings, and yet now look at me. I'm still in your court. For what reason, sir? I'm in pain, sir. They're not giving me the
hold on, Mr. Clark, hold on a moment for me, okay? Just give me a second, okay?
Sir, I'm just, yes, sir.
All right.
You answer like this situation. I just want to get in and get out, sir. Like, I'm not supposed to be here. Please.
Okay, Mr. Clark, you're in here charged with criminal trespass and giving false name and obstruction of a law enforcement officer, okay? So that's what we're gonna address today, okay? Let's see, Ms. Harmon. Oh, I'm sorry, Mr. Howard, are you there?
Mr. Howard, are you there? No, Howard isn't there, so let's move on.
Hold on for me, Mr. Clark, okay? I think you're getting your comeuppance, Mr. Howard.
40 total. He got history out of Nevada, Indiana, Illinois, and California.
Jesus. Yeah. Oh, yeah, here earlier I said about 50 arrests.
Last arrest was July 2021, theft by receiving and obstruction out of the cab.
July 21.
Open case in Fulton County for burglary in the second, criminal damage to property in the second, theft by taking. It's 22 SC 182060. Got 3 counts of obstruction, 2 counts of simple battery, 20 CP 193391.
Really?
Yeah, really. You want more, Judge, or that's enough?
That's good, thank you. Ms. Harmon. You're on mute, Ms. Harmon.
Yeah, I gotta reach you.
Sorry. The offense date was 5/23/22. The location is 20 Broad Street, which is the 5 Points convenience store. The defendant was detained at the incident location after a security guard observed him shoplifting. Security declined to press the shoplifting charge, but asked the officers that responded to issue a criminal trespass warning. When the defendant was speaking to the officers, he did give the false name of Dion Jones. As officers were attempting to transfer custody from the security guard to themselves, the defendant stiffened his hands in an attempt not to place his hands behind his back. He then handcuffed himself to a soda wire rack. He was irate and combative, and he knocked over the beverages on the rack. The total damage there was $144.47. He was subsequently arrested with the assistance of multiple officers. There is a 2019 FTA. Mr. Howard did mention that he's a multi-state offender across 5 states. I found through his GCICs 12 similar offenses to the offenses that we're here on today, Your Honor. In addition to the open cases that involve similar offenses, we believe that he has a high risk of reoffense. For the criminal trespass, we're recommending a $500 surety bond. For the false name, we're recommending a $500 surety bond. For the obstruction, we're recommending a $4,000 surety bond, a 1-day anger awareness, no alcohol, drugs, or weapons, and stay away from the incident location. And again, we're recommending those bond amounts because of his criminal history, which is largely the same offenses.
Okay, Ms. Giddings.
Yes, Your Honor. Mr. Clark is employed at a catering service as a dishwasher. He has a high school diploma. He has some college. He is a United States veteran from the U.S. Marine Corps, and he is currently employed part-time as that dishwasher. He has one daughter, 4 years of age, that he is helping to support, and he currently lives with a roommate. As Your Honor can see, he has a fractured skull as well as a neck injury, and he has indicated that he is in a lot of pain. I have expressed to him vehemently that he is not to return to the 5 Points convenience store, or else he will be arrested and the police will be called when they do see him. We would ask, Your Honor, his history notwithstanding, for a split bond, $500 through the jail on the giving false information to the police, a $500 through the jail on the criminal trespass, damage to property, and then a $1,000 surety bond on the obstruction, as the warrant indicated he did not do any violence or attempt to do any violence to the officer in this case.
Is there any additional way that we can assist him, Ms. Giddings?
I think he was probably upstairs in medical, and they would just have to monitor him. And if there is pain to the point that they cannot help him, he would just need to be transported to Grady, because the jail is not going to prescribe or.
You went on mute, Ms. Giddings.
Greater than Motrin or ibuprofen 800 milligrams, because they don't dispense narcotics at the jail.
So he has a place to live?
Yes, Your Honor, he does.
I guess my question was going more to his mental health.
I did get into that with him, and he's just a little agitated because of his injuries and how it all stemmed and worked out. And I just told him, don't handcuff yourself to anything else if that is what you actually did. As those are allegations, they're not facts. That's just an allegation, but you don't need to be handcuffing yourself to things in establishments. But he does have a place to live, Your Honor. His address is listed on his booking sheet. I did verify with him, and he has a roommate that he is sharing rent with. His half of the rent is approximately $700 a month.
Okay. Mr. Clark.
Yes, Your Honor.
If I let you out, are you gonna promise me that you're not gonna go back to that 5 Point store?
Oh, absolutely. That was a horrible decision, but I know.
Okay.
Never to go there again.
All right, so I don't want you going back to that 5 Point store, and if you do, they're gonna call the police, and you're gonna be right back where you are, okay? So I see that you're in distress, so it's gonna be a $500 signature bond through the jail for each count.
Thank you so much.
It's gonna be a $1,500 signature bond total, and you're not to go back to Broad Street. And
Not a problem.
no drugs, alcohol, or weapons. You can have prescription medication, of course, but okay.
Yes, sir.
All right.
Almost, sir. I'm related. I just can't really show it. You need some pain, man. Thank you.
Okay.
Thank
Mr.
you,
Clark.
You're welcome, sir. You're welcome, Mr. Clark. Good luck to you. Thank you, Your Honor.
Okay. All right. That concludes today's calendar. Anything else from anyone?
No, Your Honor.
No, you're right.
We'll see.
Good to see you, Judge.
Thank you.
All right. We'll see y'all next time.
Okay.
All right. Thank you, Judge. Good to see you.
You also, Ms. Giddings, as always. Officer Milton, quiet today.
I have 5 o'clock court.
Okay. We'll see you next time. All right.
All right.
Bye-bye.
You all have a good one. Bye-bye.